Long ago, there was the juror segregation, or segregation by law. But ever since the court case Brown v. Board, 1954, where the Supreme Court ruled that racially segregated schools violated the Equal Protection Clause of the 14th Amendment and the principle separate but equal established in Plessy v. Ferguson, 1896, was reversed, there has been de facto segregation, or segregation by fact. In addition to the court case Brown v. Board, the Civil Rights Act of 1964 also worked towards the outlawing of segregation in public facilities. Today, the debate over affirmative action, policies designed to increase the participation of underrepresented minorities and women in business, unemployment, and education is represented in many of the Supreme Court's federal cases. One of the Supreme Court's federal cases in which affirmative action is clearly demonstrated was in Adarand v. Pena, 1995, where the United States Department of Transportation, DOT, gave a highway construction contract in Colorado to Mountain Gravel and Construction Company. Mountain Gravel then requested bids for a subcontract for guardrails along the highway. Adarand, a contractor specializing in highway guardrail work, presented the lowest bid as a constructor for part of a project funded by the United States Department of Transportation. Under the terms of the federal contract, Mountain Gravel would receive additional compensation if it hired small businesses controlled by unrepresented minorities. Another subcontractor, Gonzalez Construction Company, was given the work because it was certified as a minority business and Adarand was not. In this case, Mountain Gravel and Construction Company, Adarand Constructions, Gonzalez Construction Company, and the United States Department of Transportation were all involved, but Adarand Constructions were affected because Gonzalez Construction Company was hired over them. Although Adarand Constructions were not awarded the project, they filed suit in federal court against DOT, arguing that the subcontracting incentive that caused Adarand to lose his subcontract was unconstitutional because it represented a case of reverse discrimination under one of the negative results of affirmative action. In this federal court case, Adarand Constructions used the Fifth Amendment, arguing that they should be as equally protected as underrepresented minorities. Under Justice O'Connor's opinion for the court, it was argued that all governmental racial classification must be analyzed under a strict scrutiny standard. Thus, the case was sent back to the lower courts for a decision concerning whether the program was unconstitutional according to the strict scrutiny standard, which required the program be justified by a compelling reason and be specially made to eliminate discrimination that could be proven, not just discrimination by generalization.
Petitioner Adarand Constructors filed suit against federal officials claiming that the race-based presumptions used in subcontractor compensation clause violated the equal protection component of the Fifth Amendment due process clause. The court held that all racial classifications must pass strict scrutiny review whether imposed by federal, state, or local authorities. Strict scrutiny is a form of judicial review that courts use to determine the constitutionality of certain laws. For a court to apply strict scrutiny, the legislator must either have significantly started a fundamental right with the laws enacted or have passed a law that involves a suspect classification. A suspect classification involves race, national origin, religion, and poverty. The court added that programs which are based on disadvantage rather than race would be evaluated under law equal protection standards. There were 5 votes for Adarand and 4 votes against. The The Supreme Court's ruling in Adarand versus Pena did not automatically overturn the DOT program challenged by Peck. Instead, the ruling sent the case back to the lower courts for a decision concerning whether the program was unconstitutional according to the strict scrutiny standard. As expected, the lower courts soon determined that the program violated the constitutional rights of non-minority contractors such as Adarand.
In the summer of 1978, the United States Supreme Court ruled on the court case of Regents of the University of California versus Bakke. This was an example of affirmative action, and they held into consideration whether race could be used as an acceptance factor or not. Bakke filed an action in state court to be admitted to the University of California at Davis's medical program. He had a higher GPA than most candidates and was still not accepted because of the fact that 16 spots out of the 100 were made for minorities, and he was not part of a minority. The main justices were Chief Justice Warren E. Burger and Associate Justice Thurgood Marshall, and what they ended up discovering was that this court case violated Section 6 of the Civil Rights Act of 1964, and they ruled against the Regents of the University of California. They eventually came to the conclusion that race could be used as an acceptance factor, but it cannot be the sole factor when admitting a student to a university.